Good afternoon. It's my pleasure and privilege to be able to introduce our speakers for this next section on governance-related perspectives. First up, we will have Luis Aguilar, DSPT. They're all four DSPT fellows, so I won't say that for everyone. But first up, Luis Aguilar. He's the founding director of the Institute of Public Policy and Governance at the University of Guadalajara. He will be followed by Patrick Brennan, professor of law and John F. Scarpa Chair in Catholic Legal Studies at Villanova University. Then will be Dan Lundgren, lawyer, former U.S. Congressman, and former Attorney General of the state of California. After the three presenters have spoken, Ned DeLacy, the Executive Director of the California Catholic Conference, which is the public policy arm of the Catholic Church in California, will offer a brief response.
Very grateful to Father Peter, to Father Michael, for inviting me to take part in this intellectually rich convocation. I will speak on governance, concept and approach. It was easier to speak about governance before 2016, Annus Horribilis, in which the symptom of democratic fatigue, as it has been called, manifested itself in different forms. Brexit, Trump's offensive and post-truth electoral campaign, the rising wave of right-wing xenophobic populism in Europe, Russia's electoral intrusion damaging democratic process and outcomes, the humanitarian catastrophe in Syria, the refugee crisis, the overflow of migratory phenomena, among other topics. We are living in an uncertain time where fears can lead us to look for quick and easy answers that are often wrong and harmful. Not to mention opposed to the founding values of the Western tradition that was in large part created and framed by Christianity. By the way, allow me to suggest you to read two recent and provocative books published 4 or 5 months ago. The first one is written by Jason, not Patrick Brennan, is Against Democracy, Princeton University Press. The second book is written by a Belgian professor, David van Rijbroek, is Against Elections, the Case for Democracy. Let us get into our subject, the shift from government to governance. The shift from government to governance is an expression that sums up the changes taking place in reality and in the study of government, public policy, and public administration. Governance as a concept and approach is new and attempts to provide an answer to a new question, the question on the ruling capacity and efficacy of democratic governments in contemporary society. The question of whether governments are really capable of governing, leading, coordinating is now the most relevant and worrying question today when most countries, developed and underdeveloped ones, are undergoing economic decay, distressing social changes, and political delusion. The shift from government to governance has been triggered both by factors internal and external to government. Internal factors include budget deficits, fiscal crisis, poor political representation of citizens, corruption, etc. External factors include economic globalization, cultural globalization, the dominance of financial capital transactions, political and ethical plurality, and the growing individualization of society, breaking traditional social bonds, etc. The combination of both the internal and external factors have altered government-society relations, and hence cognitive and political attention moved from the study of government as agency, institution, bureaucratic arrangement, to study the process by which government rules, steers society, determining the conditions that enable a proper and effective steering process under contemporary circumstances. The shift from government to governance has two main reasons. First, the illegitimacy of government is no longer a pressing problem. It was solved by reinstating the rule of law and by democratizing political regimes. Second, the problem of cost inefficiency or cost ineffectiveness of governmental public policies and services, even if protracted and aggravated, is no longer relevant. There are many measures, policy adjustments, public management, new public management, which allow us to deal with those problems. Rather than inefficiency, the present problem is the government's insufficiency. The government's insufficiency for ruling, steering, and leading the society. Governments by themselves lack the resources, financial, cognitive, organizational, even moral, like credibility and social trust, required to govern, build a sense of direction to society, safeguard the founding values of society, protect citizen rights without exception or discrimination, solve public problems, etc. And the traditional ruling tools of governing, command and control, through regulations, bureaucratic procedures, police enforcement, etc., have lost effectiveness when addressing a number of contemporary public problems which have a highly complex configuration and are effects of various entwined causal chains that becoming unmanageable by the government's usual hierarchical tools and its available resources. The complexity of society is the main issue, but we are not to address this afternoon. Furthermore, the relative inefficacy of the traditional hierarchical model of government is the consequence of a proactive civil and economic society that is politically independent, powerful, informed, cognizant, and is unwilling to simply abide by governmental decisions that affect personal and social lives, particularly when those decisions are considered mistaken or unfair. This proactive civil and economic society, therefore, demands access to both the public decision-making and the implementation process. On the other hand, a dynamic knowledge society, economic society, has shaped economic output, labor, transactions, communication, the well-being of society, as well as its evolution. This knowledge society of autonomous individuals, corporations, organizations with interdependent links has the capacity to question unfounded policy decisions, lacking in proven scientific knowledge, as well as to provide scientific technical validation in the form of counsel and engagement in the public decision-making process. Definition of governance. it's important to have a clear and robust definition of governance. Public governance refers to the process by which a society steers, rules, and manages itself, meaning essentially the process by which government, private corporations, civil society organizations, and citizens interact to define, agree, and decide on the founding values of their common life, on their common goals, and on the organizational forms, exchanges, kind of resources, and set of activities which are necessary and fit to carry out successfully the chosen goals and the guarantee common values. What is important is that governance process is structured. It's structured by institutions and by knowledge. On one hand, the governance process implies values, institutions, rules, traditions, which establish the ways and limits of the exercise of public power and the channels open to citizens to participate in public decisions. Institutions regulate as well the interactions between public authorities, private corporations, and civil society organizations in order to articulate their interests, meet their differences, and reach agreements on public issues. On the other hand, public governance also implies scientific technical knowledge that enables the public, private, and social actors to determine the proper causal activities to produce effectively the agreed upon public goals, as well the efficient allocation of public and private resources. Institutions determine the social legitimacy of the governance process, while the knowledge systems defines its feasibility, what government, together with society, can do. Governance is an intentional process oriented toward specific common goals and ends, which refer to a socially accepted value system, and it is also a performative process committed to achieving the common ends and goals, which refer to a socially accepted knowledge system. Hence, the governance process has two essential dimensions, a value dimension and a technical scientific dimension. Governance in sum relies on criteria and assertions of truth, cognitive validity within the value domain and within the technical scientific domain. What is to be avoided in the present is that technical reason, an instrumental reason, overpowers substantive reason. Moreover, stronger emphasis should be placed on the relevance of dialogic reason, of conversation, through which the political and social actors build, debate, test, and validate its propositions and assumptions. Three types of governance have taken place throughout social history. Excluding the recent governance by markets, the public governance has three types. All types of governance are dependent on how government and society interact to determine their values and objectives, the organizational forms, the resources, and the causally most effective actions to achieve the desired ends. It is well known that government, at times, has been the sole decision maker regarding governance, in large part due to inabilities, unproductiveness, conflict, crime, violence, internal divisions in society. In other instances, society has exhibited capability of self-regulation, integration, economic growth, and stability. Most recently, government and society are becoming interdependent, acknowledging their complementarity, which is necessary both to outline their objectives and also to achieve them through dialogue, negotiation, agreements, and partnerships. The first type is the called governance by government. That is the hierarchical governance. But there is also self-governance by society. There are multiple examples, old and new, of society self-governance as a whole or in specific societal issues. The subsidiarity governance belongs to this second type. We have lived in governance processes by government, but there are alive a lot of processes of society self-regulation. But the final contemporary type is co-governance. This is the modern governance, which takes place when government and society recognize that they depend on one another to achieve their objectives. It's governance through conversation, co-decision, co-production, cooperation, and co-responsibility by means of networks, alliances, public-private people partnerships, and so on. From this long review, I would like to highlight the following ideas related to the stewardship of knowledge and evangelization in our culture. Truth, cognitive validity, is still present and increasing in relevance for modern contemporary governance. Though we observe post-truth politics that mobilize social prejudices, fears, and irrational biases, the encouraging fact is that governments cannot effectively lead without referency values, which demand rational validation and defense, and without relating causes, which demand an empirical assessment. Every social time demonstrates that power is not the last reference. If today the central question is on the capability of government to steer the society, because it's insufficient, the implication is that governments will not be able to be leaders or directors if those in power make decisions not sustained or endorsed by ethical reason and empirical evidence. Our church has a key role to play, calling for good reasons. My second comment is on government's insufficiency. A new steering process has emerged centered on the feature that the government depends increasingly on other organizations, economic and civil, to set a public agenda and to achieve public goals of common interest, just as corporations and civil society depend on the state's performance to achieve their own goals. The interdependency, complexity and interdependency in the contemporary society are linked. The interdependency of the constituent parts of the contemporary social system fosters a way of governing which is necessarily less hierarchical and more shared with citizens through partnership networks in which state and other organizations depend on each other. The present situation opens opportunities on certain matters for economic agents, civil society, and for the church itself to keep vigilant oversight on the decision-making process in governance in order to uphold the validity of fundamental human and social values founded on intellectual reason, and to advocate a trustworthy and truthfully governmental discourse. A deaf government, to the voices of key sectors of society, loses legitimacy, trust, and support, and condemns itself to a contested leadership. The third point is on subsidiarity governance, a form of government and policy principle in accordance to the church social teachings. And subsidiarity governance is bound to become more and more the future governance pattern in those societies which have reached high levels of information and knowledge, large economic output, self-regulation, cohesion, and wide social capital, regardless of its multi-ethnic or multicultural composition. Well, I think that to preach, to vindicate, validate, and explain the ecumenical, global message of human dignity, rights, liberty, and responsibility is the eternal mission of the Church when referring to the secular, social, and political components of human life. Thank you very much.
It's always wonderful to be back in Berkeley. One learns a lot here, and not always from the expected sources. When I landed at SFO a couple of days ago, I then, in an unusual moment of public spiritedness, took BART. And when I arrived in downtown Berkeley, summoned the ubiquitous Uber. And as I was traveling to where I was going to be staying, I realized I was coming from Philadelphia that my overcoat was stuck in the door. And so I opened the door slightly to pull in my coat, and suddenly I heard someone yelling at me, "Don't ever do that again." It was a bicyclist who was threatened by my opening the door, and I said, not missing a beat, "I promise I'll never do it again." Life in Philadelphia, strangely, is more relaxed than I found Berkeley. The life of the law, Oliver Wendell Holmes Jr. famously wrote in the first sentence of his magisterial book, The Common Law, has not been logic, it has been experience. Holmes's target was the formalism in law then in vogue in the United States, according to which the practice of law ought asymptotically to approach the method of geometry. Holmes's criticism should, to a point, be well taken, though today no educated person would be need to talked out of the misunderstanding of law in more geometrico. My interest here, therefore, is what lurks in the other horn of the false dilemma propounded by Holmes, experience. Having delivered law from the dead hand of geometry, Holmes, by a sleight of hand, reduced life's law to mere experience. In law, as in the rest of human living, experience is ordinarily only just a beginning. And this, I think, is the crucial point to be unpacked. In the rest of human living, we experience, we understand, we judge, and we decide. And sometimes, I'm obviously tracking Lonergan here, we fall in love. We wonder, we ask questions, we answer the questions, and we reach judgments, which in some parts of life are certain, but in practical affairs are usually only probable. We experience, we understand, we judge, decide, and if we're able, we fall in love. What I've just provided in the worst summary form is not a metaphysics, not an epistemology, but, if you will excuse the term, a gnoseology. This unfamiliar but well-attested, if uncouth word, refers to an account of what it is that we are doing, the operations we are performing when we are knowing. A metaphysics offers an account of what is, and epistemology offers an account of the necessary and sufficient conditions of human knowing, and a gnoseology states what it is that humans are doing when they are knowing. As an aside, but more than an aside, we do well to note that the reason gnoseologies are so rare is that, as Lonergan observed, human intelligence, intellectus as it used to be called, is often treated as a black box, the interior life, if it has one, of which is not available for inspection even to the person whose intellectus it is. To rest content with experience as an exhaustive alternative to logic is just one clear and proximate example of how human understanding gets left out of the picture of what humans can and should do. Returning then to my theme, I can anticipate any number of objections to the gnoseology I've proffered in summary form, and I would welcome a further opportunity on another occasion to meet them. My present point, however, is this, and I conceive it to be beyond dispute. Whatever knowings we achieve in law are the product of whatever operations humans perform whenever they do any kind of knowing whatsoever. Knowing in law, in other words, is neither exempt from nor an epistemically privileged form of the cognitive operations, the proper performance of which leads to whatever knowings humans achieve. None of this is to suggest that law is not what we might call a particular specialized instance of the basic pattern of human knowing. On the contrary, law does indeed have its own characteristic and malleable methods and modes, each and all of which can and should be evaluated for their merits in harnessing the method of human understanding itself for the achievement of the ends or goals that are the proper domain of law. What practitioners of law cannot do, except at law's peril, is to proceed or purport to proceed according to methods or modes that are not isomorphic with the method of human understanding itself. The substitution of mere experience for knowing would assure just such peril. Which brings me back to Holmes, whom I'd like to use briefly as a test case by which to unpack further how practitioners of law achieve law. The same Holmes who had assigned the life of the law to mere experience was later the author of the Supreme Court's opinion in Buck against Bell, the case that upheld, against constitutional challenge, a Virginia statute permitting the compulsory sterilization of those who, now in Holmes's words for the court, are, quote, manifestly unfit from continuing their kind, close quote. Holmes's opinion for 8 members of a 9-member court ran a mere 5 paragraphs, leading one legal scholar to observe recently that the opinions Holmes wrote achieves, quote, the highest ratio of injustice per word ever signed on to by 8 justices of the Supreme Court, progressives and conservatives alike. Only one justice, Pierce Butler, filed a dissent, about which more momentarily. Proceeding from whether it amounted to injustice or not, I think the answer is clear, the question remains, on what basis did Holmes, acting as a justice of the Supreme Court of the United States of America, reach this bracing, one might even be inclined to say barbaric, conclusion in the name of the law? Here, with nothing of substance elided, is what Holmes wrote for the court. Quote, we have seen more than once that the public welfare may call upon the best citizens for their lives. Holmes had been severely injured fighting in the Civil War. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped by incompetence. It is better for all the world if, instead of waiting to execute degenerate offspring for crime or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. And now to the clincher. Quote, the principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough, close quote. And with that, the opinion rested, except for a brief anticipation of a counter-argument about which I'll say nothing. Most among us are repelled by the result in Buck and by the court's language in defense of it. But from repulsion, it does not follow that the decision was wrong as a matter of law. What then was the legal problem, if any, vitiating or at least compromising the majority's decision in Buck against Bell? A juxtaposing of two thoughts Holmes shared with his friends concerning the decision in the case will provide the beginnings of an answer. The first, written while the case was pending, quote, Butler, Justice Pierce Butler, knows this is good law. I wonder whether he will have the courage to vote with us despite his religion. Butler was a Catholic, the only Catholic on the court at the time who is reputed to have gone to Mass daily. The second, written to Harold Lasky immediately after the case was decided, quote, I wrote and delivered a decision upholding the constitutionality of a state law sterilizing infants, the other day, and felt that I was getting near to the first principle of real reform, close quote. As to the latter, Holmes's getting near to the first principle of real reform was emphatically not a matter of what we call today pejoratively judicial activism. And for this reason, it cannot be dispatched to one of the usual pigeonholes of superficial analysis. After all, at least from one point of view, Holmes and his seven brethren who joined the opinion did neither more nor less than read the Constitution of the United States and conclude that it did not require nor even allow refusing effect to the Virginia statute. On this view, the legislators of Virginia were the reformers, which assuredly they were, while the Supreme Court, including Holmes, were not reformers at all, but rather mere rule followers, followers of the rule that statutes that do not offend against the Constitution must be given effect despite any moral repugnance they might engender. From another point of view, however, the court was doing far more than the rule-following model excuse suggests. Specifically, the court was choosing among several legally available options when it chose to conclude that the Constitution provided no legal impediment to the reform wrought by the Virginia statute. The justices who found or rendered the Constitution itself impotent in the face of a compulsory sterilization statute knew perfectly well that other majorities of the same court had in the then recent past found in the Constitution substance calling for the invalidation of reform statutes. The textbook example is, of course, Lochner against New York, the case decided in 1905 that held that the 14th Amendment included a right of contract that rendered unconstitutional New York's limits, statutory limits, on the hours bakers could work. Holmes, however, was not among the justices invalidating the New York statute challenged in Lochner, for which reason Holmes can be credited with, at least, consistency. But consistency fails to capture the jurisprudential commitment at work in Holmes's judging because, we can recall, in anticipation of a possible dissent by Justice Butler, Holmes contended that the Virginia compulsory sterilization statute was, quote, good law, close quote. By good law, Holmes surely did not mean that the Virginia statute was valid because it was a demonstrably prudential derivation from the first precept of the natural law, to wit, that the good is to be done and pursued and evil avoided. Holmes had no time for the natural law as it was understood by the Central Western tradition, another point to which I'll return. Holmes, by the way, when it was suggested to him by his friend Monsignor Sheehan that he read Suarez and Dante, said that he couldn't possibly learn anything from either of those. He later did read Dante and claims to have taken something away. It's not known whether he ever read Suarez. What then did Holmes mean by good law? Given what he wrote to Lasky about how he had approached the principle of real reform, as well as what we know from other sources, including the man himself, about his enthusiasm for Darwinism and eugenics, we can be confident that he believed that the statute embodied, while permitting compulsory mutilation of the body, good in the sense of very, very, very useful policy. What Holmes meant by good law, however, because this is how lawyers talk, was exactly that the challenged Virginia statute was valid because it had been enacted in a procedurally proper way. by the Virginia legislature and did not violate any constitutional guarantees of the U.S. Constitution, nor, though the issue was not before the court, any guarantees of the Virginia Constitution. In sum, Holmes's lawyerly points about good law were, first, that the statute's pedigree was good, and second, that the pedigree was sufficient for legal validity. Granting for the sake of argument that the pedigree was indeed worthy of one of my favorite movies, Best in Class, was that, in fact, sufficient reason for the court to uphold the statute? Or would the better view be that the court should be understood to possess the authority, as opposed to sheer power, to refuse effect to a statute that, though perfectly pedigreed, is unjust or immoral? The latter line of questioning obviously raises issues of a piece with those we discussed here last year, but now with the tables turned upside down. In the same-sex marriage arena, the court rose to assert judicial authority to strike down as unconstitutional statutes that do not recognize same-sex unions as marriage in law. And let there be no mistake about it, the pedigree of the statutes found unconstitutional in Obergefell was unquestioned because unquestionable. It was the substance that was the asserted defect justifying a finding of unconstitutionality. The question then boils down to this: how can the same Constitution pose no barrier to compulsory sterilization, but deal a fatal blow to restricting marriage to opposite-sex couples? The short answer, of course, is substantive due process, that well-entrenched oxymoron. And also the well-attested but arguably textually unfounded doctrine according to which the courts, on the basis of the due process clauses of the Fifth and 14th Amendments, respectively. Holmes refused to require due substance in Buck against Bell, as he had in the other case to which I alluded, Lochner. But why? Why should someone be so keen on reform refuse to avail himself of an attested judicial authority to invalidate statutes for want of sound substance, as the Lochner majority did? Holmes's self-denying judicial posture in Buck, as in the other cases, had grounding deeper than his contingent preference for the reform results reached by the legislature in the statutes under review. Consider the following vignette provided by Judge Learned Hand, perhaps the most well-remembered American judge who never served on the Supreme Court. I'm quoting Hand now. "I remember once I was with Justice Holmes. It was a Saturday when the court was to confer. It was before we had a motor car, and we jogged along in an old coupe. When we got down to the Capitol, I wanted to provoke a response, so as he walked off, I said to him, 'Well, sir, goodbye. Do justice.' He turned quite sharply, and he said, 'Come here, come here.' I answered, 'Oh, I know, I know.' He replied, 'That is not my job. My job is to play the game according to the rules.'" Close quote. Holmes is by no means a sympathetic character, and he is well and deservedly known for arguing that one can best understand the law by wringing out of it one's thought of moral considerations. I nonetheless follow H. Jefferson Powell, professor of law and divinity at Duke, in construing Hand's vignette as a key to unlocking a fundamental jurisprudential commitment on the part of Holmes that is conspicuous, above all, ironically, for its self-abnegation. Holmes told Hand that my job is to play the game according to the rules. Holmes did not attempt to explain the point of the game, nor did he specify the rules that define the game. Instead, according to Powell, quote, "he expressed a certain attitude, a moral attitude toward his place within that practice, whatever it means to act as a judge, and whatever the point of society giving people that role. As a justice of the Supreme Court, Holmes's job, as he saw it, was to fill the role, to play the game as, I think we can interpolate, this is still Jefferson Powell, people generally understand the game according to the rules generally accepted," close quote. Further explicating what he takes to be Holmes's position, Powell explains, quote, "the obligation to remain within the role is itself a moral obligation. Justice Holmes, if this is right, was not denying, but rather insisting on the presence of a moral dimension to the role of the judge," close quote. In sum, the judge does not go beyond his role, not because he does not care about morality, but exactly because he does care. But this, of course, necessarily leads to the question, what are the ethical obligations and commitments of the judicial role under our Constitution? The answer to this question is, again, complex, but Powell's, I think, accurate account of Holmes's understanding of the judicial role, which is, in turn, Powell's own understanding, is this. Constitutional law is intrinsically a moral activity, just as Hand understood Justice Holmes to imply. But the ethical aspect of constitutional decision-making does not lie, at least not proximately, in the decision-maker's conformity to extra-constitutional moral criteria, such as doing justice. The rules by which we play the constitutional game are not external, but, again as Holmes implied, internal to the game. Constitutional law is something we do, not something we have as a consequence of something we do. Powell proceeds over the course of the remainder of the book from which I'm quoting, called Constitutional Conscience, to make a persuasive case, to make as persuasive a case as I've seen for treating constitutional law and the judge's role therein as a matter of playing the particular game that is constitutional law by the rules. To be clear, there's nothing in the nature of a constitutional rule per se that precludes it from allowing or even requiring recourse to sources outside of the constitutional text itself. Even a set of constitutional rules that includes at least one such rule suffers, however, from a terminal defect that I shall call premature closure. The point of a game, in the usual sense of the term, is exhaustively given in the instructions or rules of the game, which, of course, are of human construction. The point of human life, however, is not of human construction, at least not ultimately. The ultimate point of human life is given by nature and by supernature, and moreover, it is not given all at once as an epistemic matter. It is discovered and uncovered in the course of history, or at least it can be. Its discovery and uncovering would be a choice. The choice to treat law as a game of rules imposes a closure that is premature exactly because individuals and their society's obligations to discover and conform to the naturally given point of human life is non-defeasible, or so Christians ought to contend. The alternative view, as Powell observes, emerges from the transfer of sovereignty, as under the U.S. Constitution, from state to the people. The crucial and novel feature of American constitutionalism, according to Powell, was, I think correctly, the separation, correctly as a report, not a normative judgment, was the separation of sovereignty from the state. If the sovereign is distinct from the government, then the instruments of state can be limited in their authority, and the idea of a written constitution becomes possible. Powell continues, quoting Philip Bobbitt, "Thus, in American society, questions of the constitutional structure and powers of the state have become lawyers' questions, and the power of the state, no longer sovereign, has been put under the law, the Constitution, and thus put under the common law forms of argument that were originally and have remained what defines legal argument. Something counts as a constitutional argument. It is a move according to the rules of the game if it takes the form of one of the recognized modalities of common law argument, because they are the grammar of constitutional law, that system of logical constraints that the practices of legal activities have developed in our particular culture. If, as Powell and Bobbitt contend, and I think correctly, constitutional argument, in order to avoid becoming ungrammatical and therefore legally irrelevant, must follow the recognized modalities of common law argument, it does not follow, indeed it's a contradiction of the fundamental presuppositions of the common law, that it is a closed system. A written constitution is indeed susceptible of interpretation according to the common law modalities of argumentation, but the common law modalities of argumentation become something other and less than they were if and when their scope and horizon are, however carefully, limited and capped. Powell defends a closed constitutional universe driven within its delimited ambit by the recognized modalities of common law argument by several contrasts, one of which is that the U.S. Constitution itself requires judges and justices to seek in each case, quote, to reach the outcome that is in fact the humanly best outcome possible in terms of justice, close quote. Notice that this contrasting position posits that the Constitution itself, not say the judge's non-textually moored preferences or commitments or ideals require the humanly best possible outcome. The reason Powell gives for rejecting this as an available interpretation of the Constitution, and thus of exercising the judicial role under our Constitution, is that because, quote, decisions about the best human outcome depend, much of the time, on substantive and highly contestable accounts about what is, in fact, the human good, close quote from Powell. Such decisions should be avoided whenever possible, exactly because they sow divisions, so Powell contends, within the republic that the Constitution is meant, think Lincoln, to bind together. Now I quote Powell again. At least in cases not driven by obstinately precise constitutional text, the president must be at least 35, the court does not replace mistaken views of the Constitution's goals with correct ones. It merely substitutes the debatable views of a majority of, say, Congress with the equally debatable views of 5 or more justices. That such judgments are and must be made can be taken for granted, says Powell. That such judgments can be a regular feature of constitutional adjudication by the court is a view that threatens to transform judicial review into a means of partisan dispute. Is this view correct? The preceding question is the very one Powell rules out as possible within constitutional argument that constitutes our republic. Now, I have more text written here, but I don't have time to read it, so I'd just like to touch on a few points by way of conclusion. What I began by arguing is that any knowing in law, if it's to succeed, must be based on a method that is, as I put it, isomorphic with the method of human understanding, both theoretical and practical. Treating texts, even the Constitution, as not susceptible of the common law modes of argument, but instead as simply a set of rules to be followed, it seems to me, has been, and I talked about this last year, our generation's and our culture's attempt to stop what is perceived as cultural decay in its tracks by treating the Constitution, again, as an exhaustive set of rules that are not open in the sense that common law argument was. Justice Scalia once said, mocking the common law as a Mr. Fix-It mentality, that the common law was like playing Scrabble. You couldn't take things away, but you could just add to them. That was the genius of the common law, one step at a time. And as Marianne Glendon has pointed out, herself a student of Lonergan in this as in so many other respects, the method of the common law was what we've known since ancient times as dialectical reason. And what the common law judges did quietly, without much notice, was to engage in dialectical argument. Yes, also using analogies, also using induction and deduction, but above all, engaging in dialectic with a view toward instantiating individual and the common good. So my conclusion is that we live awash in an ocean of law. When law is treated as it is so often in our culture, as exactly what the sovereign posits, legal positivism is the name of this view, law is all and only what the sovereign posits. And therefore, you better write it all down. You need to keep writing laws down because law does not also consist of the first precepts of the natural law clarified by the divine law. So the better understanding of law that I would put forward as an alternative to the obsession with text treated in isolation would be a recovery of the common law mode of argument now as specifically applied to the Constitution, but more broadly in our legal system. And my final point is that, with all due respect to my friend Dan, legislatures have the peculiar freedom that they don't have to give reasons. Courts have to give reasons. Even administrative agencies, though we love to vilify them, must give reasons if their actions are to survive judicial review. And it seems to me that the common law had built deep into its structure of the judicial opinion a rationality that's lost by the positivists just trying to figure out what the sovereign happened to mean the last time he happened to write something down and didn't have to give any reasons. And so, as one of the great legal scholars of the 20th century said, there are many rooms in the mansion of the law. And I think that the rush on the right, one thinks mostly of Justice Scalia, to petrified texts is a remedy that's worse than the disease. And so, as T.S. Eliot said, and Lonergan quotes him to this effect, the only method in the end, prescinding from grace, is intelligence. And it's on that basis that I would urge that we try to root law again rather than in the will of the sovereign. Thank you.
Justice Scalia hasn't been gone a year. I will just preface my remarks by one of my favorite quotes dealing with the subject that you just spoke upon. It's Judge Andrew Kleinfeld of the Ninth Circuit Court of Appeals in his dissent in the Compassion in Dying versus State of Washington case. He said that a question is important does not imply that it is constitutional. The Founding Fathers did not establish the United States as a democratic republic so that elected officials would decide trivia while all the great questions would be decided by the judiciary. That an issue is important does not mean that the people, through the democratically elected representatives, do not have the power to decide it. One might suppose that the general rule in a democratic republic would be the opposite with a few exceptions. Another point of view. Okay, I stand before you not as an academic. I'm not a social scientist. I am not a political scientist, nor a law professor. I am merely a practitioner of the arts. I always wondered why you say practice the law. Maybe it's because we never get it done perfectly. I'm a practitioner of the arts of law, politics, and governance. So I was involved in 22 elections for Congress, 4 for Attorney General, and 2 for governor, that is including primaries and generals. My record was 25-3. Unfortunately, the press just remembers the 3. So what is the relationship between the stewardship of knowledge and evangelization in my fields of endeavor? I think to understand my perspective, perhaps it is fitting for a quick review of my education and formation. I went to Catholic school my entire life. Catholic grade school, St. Barnabas in Long Beach, Catholic high school, St. Anthony's in Long Beach, University of Notre Dame. Took a sidelight to USC, which I guess Kevin Starr thinks is the largest Catholic school in America. And then I went to Georgetown. So I did get Catholic education, and then I went to a Jesuit school for law school. I learned my values and the tenets of my Catholic faith from my family and from my schooling. I learned that my life was not to be compartmentalized, but that I had to understand that I lived life as a unified living of life. They brought into clear view the fact that my faith was to animate my life with all my failings and shortcomings. So as that as a background, how do you express that, or how do you live that in the Trojan professions of law, politics, and governance? Well, perhaps most importantly, you live that by the little things you do, by the everyday things you do. And we're reminded of that from time to time when people will come up to you and remind you of something you said that you'd forgotten a long time ago, or the way you acted towards them when they were an employee or a neighbor. And perhaps the greatest compliment is when someone says, we saw how you raised your children. We've been trying to do it that same way. Or the way that you treated your employees. Things that you never thought of, but things that were animated by the faith that you were taught and the faith that you attempted to live. In fact, it's sometimes shocking to realize how people pay attention to you. And I often repeat the story that Ron told me, Ron Austin, about one of the experiences that impacted his life and, in fact, led him on his road to conversion when he was a screenwriter in Hollywood, and he walked for lunchtime, I guess it was up in Sunset or wherever it was, and he came upon a scene of someone who had committed suicide by jumping off the top of a building, and his body was laying there with something over it, and he said there were caustic remarks made by the in crowd, must have been a screenwriter, and he said as he walked by, he saw two Hispanic workers who stopped for a moment and each made the sign of the cross and then went on. And Ron has told me this many times. He said that impacted him because he said they have something I don't have. And so in many ways, it's the small things you do, the everyday things you do, the things when you are not consciously working out your faith that have perhaps the greatest impact. But I was thinking about this the other day when I happened to see some comments made by a formidable political figure these days, who in referring to members of the other party complained that they wear their religion on their sleeve. She went on to say that her opponents, and if I were still in the Congress, I would have been one of them, pray in church on Sunday, but then prey on the people the rest of the week. Somewhat of a difficult personal attack on a group. But I wondered as I pondered that, what does that mean? Was that meant to suggest that if someone brings their faith to the job of governing, that they will be met with the argument that they are parading around with religion on their sleeve? And is it an argument that those of faith can practice their faith anywhere except if they happen to be in a political office? Or does it mean that they ought to be disqualified from serving in public office because they bring their faith as part of who and what they are? You see, one of the other speakers mentioned earlier that the definition of a secular society is one in which it is more difficult to believe in God than not believe in God. And if that, in fact, is an appropriate observation of where we find ourselves, perhaps the idea that someone wears their religion on their sleeve is evidence of that. I would hope that I work to try and wear my religion in my heart and work out my job, whatever my job is, in the best way that I can. So, if you were running for office, what is your obligation? To hide your faith? To put it on your sleeve? What is it? It seems to me my obligation when I ran for office was to inform my constituents who and what I was, who and what I am. Sure, inform them of my political philosophy, certainly be open about what my positions are on current or foreseeable issues, but I also felt I have an obligation to inform my constituents or my prospective constituents as to my values and my core beliefs. Again, not wearing it on my sleeve, but I owed it to them so that when they made judgments, they would not feel that they were in some ways fooled by who I was when I was engaged in political discussion. So, when we talk about stewardship of knowledge and evangelization in present-day politics, what does that mean? Let me give you a few examples. Let me talk about primarily the social issues, because that's where it comes into play most often. And I remember on more than one occasion when I have been involved in the discussion and the issue of abortion came up, and someone would say to me or to others with whom I shared the same faith, "Oh, you're Catholic." Like, you're Catholic, so we know what you mean. Now, in one sense, that might be a compliment. You're a Catholic. You're faithful to your beliefs, so we know what you mean. But more often it was, "Oh, you're Catholic, so we know what you mean, and that doesn't count." Because you can't bring that into the discussion, because then you are imposing your ideas on us. See, the secret in the secular society is that the imposition of the secular religion is okay. But should you trespass upon that, you are the outsider looking in, and somehow you have trespassed on rights. Oh, I just remember, and I think I've mentioned this here before, one of the great quotes from my friend Henry Hyde, a great congressman from Illinois and a great defender of the unborn. He said, "I know someone who is so tolerant of other people's views that he will not impose his most deeply held views on himself." And it's funny, but isn't that what they're telling you to do? Don't impose it on, but don't even impose it on yourself, and don't express it. You might persuade someone to your point of view, and that is somehow improper in this secular society. So let me just go through quickly several issues that I had to deal with when I was in elected office and how I had to deal with it as someone who was informed as a Catholic. Meaning that I thought my decisions were informed by my Catholic faith, but I was also consistent with my obligations to defend the law, to carry out the law, to form the law. The death penalty. I was Attorney General of the state of California, where we executed the first person in 26 years. While I was Attorney General, responsible for leading the arguments before the courts. As someone growing up in Catholic school, I had been informed on the death penalty and the teachings of the church on the death penalty, and frankly, as I was growing up, the death penalty was supported by the church on a number of different arguments. And I studied those arguments, and I understood those arguments. And in many ways, it was an extension of the right of self-defense and the obligation of a society to defend itself. Pope John Paul II led what I would consider a change of somewhat in the church on that. If you look at the writings of the church, and if you look at the Catholic Catechism, it circumscribes the circumstances under which the death penalty can be used, essentially to those in which no bloodless alternative is available. As a Catholic, I looked at that, and I wrestled with that, and I considered that, and came to the conclusion that as an example of prudential judgment, it was my best judgment based on everything I knew as the top law enforcement officer of the state of California, that in fact there were not alternatives that were bloodless to the carrying out of executions in the state of California for the small number of individuals for whom the death penalty had been established by a jury and affirmed by a judge and affirmed by the appellate courts of California and the Supreme Court by way of writ of certiorari. And yet, it was a difficult question for me. But once I resolved that question in my own mind, I thought, you know, a lot of people, a disproportionate number of individuals who serve in law enforcement in California and throughout the country are Catholic. A disproportionate number of those who are our prison guards in our prison system are Catholic. And in most cases, it is likely that those who actually have to carry out the death penalty are Catholic. And I thought my church did very little in trying to explain to them that this was an area of prudential judgment, that yes, was a weighty matter, but that, as I have seen in other writings of the bishops, in areas of specific expertise, Catholic lay people are to be given, in some cases, the premium position of decision-making over others. And I had always found out that, at least my observation was, that seldom did the church fathers ever talk with those in law enforcement about what their judgments were with respect to bloodless alternatives. And so I felt there was an obligation to try and help in that regard. In another specific instance I had, the Congress, in the time that I was not in the Congress, when I was Attorney General and then for several years thereafter, and then I returned to the Congress, had passed the Defense of Marriage Act called DOMA. And it was a piece of legislation passed by the Congress, signed by President Clinton, and then it came under attack in the federal courts. Interestingly enough, when it came under federal attack, a new administration had taken office, actually two had gone, and the new administration decided that they would not defend it. And so, as the chairman of the House Administration Committee in the House of Representatives, I was responsible for following through on our responsibility of hiring counsel to defend that case before the courts. Problem is, the courts later said we had no standing to defend it. Only the federal government had the standing to defend it. Also, you remember here in the state of California, when the proposition was passed with respect to that matter, the Attorney General at the time, now the governor, originally announced that despite his problems with that law, he was going to defend it. Then he woke up one morning and said he had had a sudden inspiration that gave him problems with the law and that he would now attack the law in court. And it was then presented in court, and as was mentioned, it lost in court. And it was another example of what Judge Kleinfeld had said about that's not a trivial matter, that's an important matter, and the people of the state of California had spoken, and yet here in the state of California, the California Supreme Court decided that otherwise. But perhaps the case that I most recall well when I was Attorney General is a case called American Academy of Pediatrics versus Lundgren. This is a case involving a law that was passed that created a requirement for parental consent for minors who would otherwise seek abortions. And you may recall that ultimately we lost that case. That had remained dormant for some period of time when I became Attorney General. It had not really been pursued in terms of defense by the previous holder of that office. And so when we took over, we decided it was a properly passed law. I happen to agree with the law, both as someone who was a father and someone who understood parental rights, I thought, in this country. In this state, for instance, you cannot, at least it used to be the case, I think it still is, if you're under 16, you cannot go to a tanning studio to get tanned without the express permission of your parents. But if you're a child much below that, you can still go to a clinic at school that doesn't inform your parents to get an abortion. Interestingly, in that particular case, there are 7 people on the California Supreme Court, and one of the crucial people on that panel at the time was the longest-serving member of the California Supreme Court in history named Stanley Mosk. He was a former Attorney General. He was known as a liberal Democrat and recognized as a civil rights supporter in the early years, and someone who actually was open to discussion. And when I was talking with our staff as we were preparing for the argument before the court, I said, what we ought to do here is argue from the standpoint of the parent, because he was not only a parent but a grandparent, and I knew he had a special relationship with his family. We argued that case before the California Supreme Court, and we won 4-3, with Stanley Mosk writing the opinion. But before that decision became final, we had a stepping down on the Supreme Court. Stanley Mosk stepped down, and he was replaced by a new appointee of Pat Brown, so they asked for a reconsideration. Now, I had great hopes because the new member of the panel was Catholic and had been educated in Catholic school, but he voted for reconsideration and then ultimately voted in the opposite direction. And so inside of 6 weeks, we went from winning that case to losing that case, and now that case is stood up as one of the great examples in the United States as to why parents have no right to know if their child is contemplating and actually receiving an abortion. Obviously, I was defending a law that was passed by the state of California. It was passed appropriately. My obligation, I thought, as Attorney General of the state of California was to defend the law unless I could find no constitutional basis upon which it could be defended, even if I were to disagree with it, because the people had the right to be defended in court. But beyond that, I felt very strongly on that and worked very hard on it from a personal basis because I thought it was an extension of the argument of the worth of an individual that I believe in, but had probably first been inculcated in my belief system through my parents and through the education I got in my Catholic schools. When I was a kid growing up, I never thought there would be a conflict between being a Catholic and being a loyal member of American society, and have it suggested that if I were to be an elected official, I would have to somehow hide my faith, not under a bushel basket, but hide my faith entirely. Thank you.